Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Here to talk to you today on the Lil Durk case. We got a lot of requests of people wanting me to cover Lil Durk's case, and we know that it was set for trial when Melly's tampering case was set to go to trial, but then it got continued. In the meantime, it's been set now for a status conference on February 23rd, but recently they had this big motion pending about what evidence should come in or stay out if and when this goes to trial. It's going to go to trial. The defense had filed a motion in limine, a motion talking about 404B evidence. That's evidence of other crimes, wrongs, or acts. This extraneous or outside information that the state may try to use against Lil Durk or the other defendants. And the defense is saying that it's not admissible. Usually it's because it doesn't prove anything with respect to the allegations in this case, or if it does prove something, then there's a 403 objection where you're saying that it's more prejudicial. It creates more prejudice against the defendant than what it proves. And so therefore it's unfair. And sometimes some evidence fits that. And sometimes the prosecutor has to present a certain amount of reason why they think this evidence should come in or not. So like, what are we talking about here? The motion, they had a hearing, a big hearing on February 9th. And so all the attorneys appeared. There were 4 attorneys present and 4 defendants. The co-defendants were there, and the attorneys made the arguments about this 404B evidence that they want to keep out. And the judge took it under advisement. A lot of times we'll go in as defense attorneys and argue a motion, and the state presents their side, we present our side, and then the judge doesn't rule right then and there, which sometimes is surprising or frustrating for the defendant, and we have to wait. We have to wait and see, and the judge is going to take their time, review everything, and review their notes and the law, and then they will issue an order, a ruling, usually in writing. And so that's what happened in this case. And on February 13th, the judge issued an order, a 21-page order that went through all the different things. Now, portions of it are redacted. Redacted means that it's sealed or you can't view what that particular evidence is. But we did get some insight as to some of the things that are coming in and some of the things that will be kept out. For those of you who follow these trials involving famous rappers or in this music industry, a lot of times lyrics are being used against the defendant. And whether or not that's right or wrong or admissible or not admissible, that has become a hot topic in criminal cases. And prosecutors have really seized on music videos, music lyrics, and trying to use that as evidence of a crime. And that is what they were doing here. Now, apparently the court had previously held some other hearings on November 18th of last year and then January 7th, but deferred ruling on that motion. And then now there was, according to the court, a flurry of briefing on the issue. What's a brief? A brief is basically a memorandum of law or the attorneys filing a document in support of their position, kind of helping the judge, because we kind of take it for granted that the judge should know all of this and be up to date on the area of law or any new case law that might be in favor of one side or the other. And it's the attorney's job to actually find those cases and put it in some sort of concise format that helps the judge understand their position. And then that way, if they want to rule in the judge's favor, it almost helps do their job by getting them halfway there, because the judge can track the same language that the attorney presented. And so even though there already been hearings on this, the court says that there was a flurry of briefing on the issue, and it cites 4 different briefs that were presented on these issues. And then the government, which is the prosecution, filed their response as to why they believe the request should be denied or why this evidence should come in. And there was one issue where the government initially had indicated that they wanted to introduce evidence around a 2022 incident in Chicago. I think that there was a shooting, but the government said that they're not even going to be moving forward on that. So that was denied as moot, meaning that that's not even coming in and that they're not going to be able to talk about the 2022 Chicago incident. That was regarding a shooting at a youth center on the far south side of Chicago in 2022. So they're not going to get into that with this case. So then the court goes into the Rule 404B notice. Anytime here in Florida, it's called Williams Rule evidence. And if the state or here the government intends to use this type of evidence evidence, which is basically evidence of prior bad acts, wrongs. If they're going to use that, they have to provide the defense notice in advance and specify exactly what it is they intend to use so that we can raise an argument whether or not it is appropriate. And so the first thing that the defense argued was that it was not specific enough to meet the requirements under Rule 404B. So wanting them to be specific is important because the rule is there to prevent trial by ambush, that all of a sudden all of this stuff and evidence is coming in and we didn't have time to prepare. But the judge is saying that's not an issue here because you are having these hearings way in advance of trial. So there's no sandbagging, there's no last minute anything, so they can't really complain. And one of the things that they're complaining about is all of a sudden that the prosecution is switching their theory of prosecution, which they can do. But the allegation was the allegation originally was that Lil Durk paid someone or had a bounty, $1 million, or had put this amount that they were going to offer to pay. And that's why Quando Rondo was executed at his direction and for that payment. Now, the government is apparently going to argue that, and again, we don't know because at the trial they can still fully present the case however they want to do it, but they're going to rely on other information, the fact that almost like shouting them out, using them in videos, posting different things, that was the payment. So it's this kind of quasi payment, not a direct payment, that they are going to use as the murder for hire theory. And so as far as the notice, the judge didn't take any issue with that, but did remind them as it gets closer to trial, if all of a sudden there's some new stuff that they're planning on using, they need to be careful to really follow the rules by alerting the defense in advance if there's additional stuff they plan on using. Then the next part talks about what the court found is evidence not subject to Rule 404B. Now, other crimes or wrongs have to be of the defendant. So there's some of the evidence that the defense was seeking to exclude is stuff that's not directly related or involving Durk. And so that doesn't fall under 404B because it's not other acts of the defendant, of Lil Durk. What it is possibly something under 403, which is what I had mentioned about, is it more prejudicial? Is the fact that they're bringing in this evidence, surveillance footage and witness testimony related to the murder of DB in Atlanta on November 6, 2020, public pressure from fans of Banks and OTF demanding that Banks exact revenge for DB's murder. So those aren't things that Banks did himself, that Lil Durk did. These are things that maybe make it look bad, but it's not directly his conduct. And so the defense, if they want to keep that out, they have to use another theory, not 404B, but 403. Also, Banks was asked on a podcast if he was triggered by the Slide for Vaughn comments, and Banks responded, "For some reason, I just don't see them comments no more for some odd reason. Might be the water. We hear though." And the judge felt that he wasn't sure why the government even thought that fell under 404B, but they all conceded that it doesn't fall under this rule. The Lil Durk's attorneys are arguing that this stuff is so inextricably intertwined, or what the government wants to do is to make it seem like this is all so mixed in that it just has to come in because it's just so interrelated, and then that lets them avoid the whole 403, the more prejudicial than probative prong or objection. And so the judge on that issue, now he's going to go take those two one by one under a 403 analysis. The November 2020 murder of DB, aka King Von. So one of the things that was being sought to be kept out is the fact that King Von had been killed in November 2020. And obviously the prosecution wants to use it, the defense wants to keep it out because it seems like that's the motive, right? That's why now he wants to retaliate and go after Quando Rondo. But the court found that evidence seems plainly relevant, and that's one of the tests that the judge has to decide is it relevant to this prosecution? And he says it's definitely relevant. Yeah, this evidence seems plainly relevant to the prosecution of the case. And so the judge gives his reasons, and even though Lil Durk's attorneys try to say, oh, but then that means it's going to be like this mini trial about what happened to that, and we don't need to get into that, but the judge here found that there is a significant probative value of the altercation and what happened with all of that, and it's not cumulative. That's another 403 reason. It's either more prejudicial than probative, or you can argue that it's cumulative, meaning there are other things that say the same thing, so we don't need this extra, or there's any risk of confusion or wasting the time of the juror. And the judge found that it didn't meet any of those, that it is more probative for the government's case, and it wasn't more prejudicial, it wasn't cumulative, it didn't waste time under 403. But it does say, particularly considering the government's representation that blank, and it's redacted for these events. So I don't know what blank is, so they must have some significant support in favor of that, whether it's a witness that's going to tie it all together, whether there's some sort of smoking gun related to that. So that's denied. The whole King Von thing, that's coming in, specifically as to the surveillance footage and witness testimony surrounding the 2020 November murder of King Von. Now, the next thing the court took up was the public comments from the fans. On Durk's X account, there were anonymous users and social media comments on there, and the government thinks that they're relevant because they show that Banks was facing pressure from the public to avenge the 2020 killing of King Von. And so Durk's attorneys, they made several objections. It's inadmissible hearsay. It would add delay to the case because it requires them to authenticate, like, how are we going to authenticate that these are valid posts, explain the meanings, because even though it may have been a social media post, obviously what they're given is either screenshots or data dumps, cell phone records, and they have to authenticate that, and they have to explain their meaning, and we can't even track down all the users. And they don't have any bearing on Durk's state of mind, since the government can't even establish that he saw those comments. But the court says it agrees with the government that Banks' own statements indicate that he was aware when he was on that podcast, and that they asked him if he was triggered about the slide for Vaughn comments. And then he responded, what I said earlier, for some reason, I just don't see them comments no more. For some odd reason, might be the water, we're here though. In response, but then Lil Durk's attorneys, they counter and they're like, look, he's not being charged with seeking violence against King Von's killers. Leaks, which is leak. And so these comments that are saying to seek revenge aren't relevant to the motive in this case. But the court already explained why the murder of King Von is relevant in its opinion, and that it's relevant to proving motive for targeting the victim in this case. Or who's TB? Is that Quando Rondo? All right. And then next, the judge talks about the podcast comments, and the court rejected Lil Durk's attorney's argument that it's minimally probative, meaning it has very little probative value and it's not relevant, and the judge disagreed. And then they make another argument about it just being hyperbole, or that Banks was just talking and just playing along as part of how celebrities talk and discourse online and things like that. And the judge disagreed. So this is we're only on page 6 of 21 pages of the order. It's a lot. And I'm happy to come back and talk to you guys more and read through it or post it. For those that have the membership, we can provide that. Anyway, so far, we still have a lot to get through, and we'll just make this a part 1 and have to come back for some more on Lil Durk. There's a lot to take in because this is some really heavy legal arguments, but so far the judge does not seem to be agreeing with Durk's attorneys about what should stay out, and there's a lot more to cover. We'll come back and finish this up. Let us know your thoughts so far on what's going on in this case. Do you think that music lyrics should come in? Do you think that this evidence of the prior killing and King Von, that should have came in? Is it relevant? Is it not relevant? His comments on the podcast, let us know what you think. As always, thanks for watching and take care.